iDS Talks is a podcast dedicated to helping corporations and law firms find new and effective ways to leverage data, giving them a decisive advantage both in and out of the courtroom.
Hey, everybody. Welcome back to the iDS Talks podcast, where we seek truth through data. I am Bobby Williams, a director at iDS. Happy to be back with you, riding with my partner in stream, Drew O'Shaughnessy. Welcome back to the podcast, Drew. Good to be doing this with you again. Good, sir.
Thanks, Bobby. It's always good to be back in front of the microphone with you.
Yes. We have another special treat today. We have a couple of our iDS teammates to talk about a case that we haven't worked on, but they have a lot of interest in, and they actually published an article about it that we'll give you some information on later about how to get to. But before we start talking about the topics at hand, we want to make sure you understand that all of our observations here in this episode, they are based on information that's publicly available. We don't have any inside information. We just know what we read in the complaint and what we've seen, but we've not been retained on the matter. We're not involved in the matter. We will not speculate about the merits of the case. We won't speculate about the outcomes. We won't speculate about the conduct of any party. We're only going to talk about what we've seen in the complaint, and we're just going to opine on what our forensic and financial damages opinions are going to be about this case and cases like this. You know, I'd say this is another big swing. We take big swings at iDS. So no pun intended. Drew, why don't you tee up what we're going to be talking about today?
Yeah, I think that's two golf puns already, Bobby, in the opening statement. I think we'll set the over-under at 10 for the episode. I'll keep a little running tally somewhere.
10 under? I'll take 10 under.
10 under? Yeah. That's the third. Thank you, Teddy. Well, let's start with an introduction. So we've got Mark Clews, Teddy Brown with us today. As Bobby said, they both co-authored an article about the what is casually called the mudball litigation. It's TaylorMade v. Callaway. But Mark, why don't we start with you? Why don't you give us a little introduction of who you are, and then we'll jump over to Teddy before getting into the issues.
Sure. Thanks, Drew. My name's Mark Clews. I'm a digital forensic and eDiscovery expert. I've been working in the litigation support industry for over 25 years, specifically in digital forensics for over 20 years. And I specialize in assisting clients and their counsel with complex data challenges.
Wonderful. Teddy, quick elevator pitch on who you are.
I am managing director with the Damages and Forensic Accounting Group here at IDS. I've been on board for about 18 months, but have been practicing as a forensic accountant for over 15 years. I'm a CPA, certified fraud examiner, certified in financial forensics, and avid golfer and occasional testifier.
And I will also say, Drew, if we were handing out awards for who understood the assignment for how to dress for the episode, it would go to Teddy hands down.
That's right.
I mean, the golf vibe is real strong coming from Teddy right now.
You can't see it with the virtual background there, but Teddy's actually on the golf course right now.
It's our secret.
Right. I think one thing that Mark, Teddy, you both have in common is you are avid golfers, which I think adds certainly to the passion of an article like this and the passion of a case like this. To be able to talk about it, you can talk about it with firsthand knowledge of the products, right? It's not like so many of these cases we work on are outside of the realm of our own personal interests, but this is right there for you guys. So I'll give a quick overview of what the litigation is about, and you guys can then jump in and we'll talk about the nuts and bolts of it. So it's like I mentioned earlier, TaylorMade v. Callaway. It is the golf ball false advertising lawsuit. So essentially what the claim is TaylorMade is claiming that Callaway, through a variety of sales and marketing tactics, virtual sales and marketing tactics, in-person sales and marketing tactic, brand ambassadors, created a UV light demonstration where they shine a UV light on golf balls and compared the visuals of how a golf ball appeared under UV light for their Callaway product versus other competitors. TaylorMade is claiming that this purely has to do with the amount of reflective UV reflective chemical in the golf ball cover, has nothing to do with performance, whereas Callaway has made claims such as it is a mud ball, which Teddy, Mark, you guys know is never a good thing out on the golf course. I always try to play lift, clean, and place when I can and get the mud off the golf ball. But did I do a fair job summarizing the case? Is there anything else you guys want to add before we jump in?
No, I don't think so. I think that's a good overview.
Well, Mark, start with you then. Let's just start with a basic overview of how the forensic preservation specifically is centered around a case like this. I mean, when I think of golf ball demonstrations and golf balls in general, my mind never goes to digital forensic preservation, right? Like that, I think my first thought is the evidence is a physical golf ball. So what are the digital forensic implications of a case like this?
Yeah, the first thing that jumped out to me when I read the complaint was how are we going to identify all the custodians that may have relevant data in relation to this? If you think about traditional approaches, traditional cases, you're working with a business, you're looking at employees to identify custodians, you're able to sit down with the IT team and the legal team, and you're very quickly able to identify the custodians in question, the data systems that the business has, whether we're able to apply legal hold on their data immediately to preserve anything from being changed or deleted. And typically everything's within the company's network perimeter and under their control. But in this case, if you start thinking about all the people that are involved, the data becomes very fragmented, and it's very, a lot of it's in the large public ecosystems, such as, Instagram, YouTube, websites, wherever this video was posted. And, some of that data is going to be in third party control. Ambassador activity and influencer data will all require collaboration with them, because a lot of the times we're able to go in through the business with admin access to get the data we need. But in this case, a lot of the data will be owned by third parties. So collaboration with the owners is going to be key.
Yeah. Mark, one other thought I've got is the golf industry is the marketing of the golf industry is very relevant to whatever's happening in golf at the time. It also transitions very quickly, right? You've got new golf balls coming out every year, new products coming out every year, new demos and marketing for those products happening every year. If an athlete is working with a specific company and they win a tournament, then all the marketing shifts to get behind that athlete. I think of Rory and Nike, or Scotty Scheffler and Nike. How does the constant evolution of the marketing and golf industry impact preservation?
Yeah, it changes, especially on these living organic platforms, such as the social media platforms. What you collect today won't be what exists tomorrow, which makes it all the more important to be able to triage, especially when you start in scoping out a project like this, is to triage the volatility of the data. Identify what we need to collect immediately, and the ones that we can push to the side because we know that we're able to put legal holds or other types of protection against that data. So, there's going to be a complete, there's going to be certain types of data that are going to come from the business, and that's going to be looking at business type Word documents, PowerPoints, Slack messages, communications internally, that we're probably will be able to preserve through the business themselves. But the more publicly stuff, which can be edited and deleted from multiple access points, that can change so quick. They're the ones you really want to concentrate on and preserve quickly, especially as, you know, the deleted posts are typically not recoverable. So as you say, as they start changing technologies and they start bringing out new balls, etc., it's possible past posts and evidence could be deleted. And once that happens, it's very challenging to recover that.
You know, Mark, as you are talking, a couple of things come to mind. One thing is that it's serendipitous that you and I, two forensic practitioners, are both on the call, because I think you would agree with me that typically over the course of our careers, we've heard a refrain on many different case types that there's no data that's going to be helpful on this matter. There's no reason for us to have to do a preservation, and we have found that there is data that can make a difference or have an impact in virtually every matter. It doesn't matter what the industry type is. It doesn't matter what the case type is. So usually if we're taking the perspective that there's not going to be helpful data, we're just ignoring data that would potentially be helpful. And that's when Drew asked you that question, you immediately went into, you know, all these potentially relevant data sources that might be helpful. The second thing is it's serendipitous that both Drew and Teddy are on the call because it goes cross-discipline. As you were talking, I was thinking not just about the financial impacts of cases like this, which Teddy would go into how he would address that, but I was thinking about open source intelligence all over what Mark was talking about, how even doing an initial assessment of what data might be available and what platforms might have useful data. And Drew, that's your specialty,
Yep.
you know, just kind of taking a look and seeing what we can scrape that's publicly available that might be helpful. So both of those things came to mind while you were answering, Mark.
Yeah. You know, Bobby, while you say that, I've got a thought as well. You know, there's so much of this that, like you say, is cross industry, cross platform. You know, Mark, so much of what you were talking about was specifically related to influencers and individuals retained by Callaway or at the direction of Callaway or posted by Callaway themselves on their social media platforms. But using something like open source intelligence, we can often see the impact that and the ripples that something like that, like those posts would make, right? The individuals that then are not paid and not told the direction of Callaway, but are repeating that content. Teddy, how did the damages get equated, and how does that ripple effect impact how damages are equated? Does that have an impact on it?
No, it certainly does, and I think it depends on which side of the V that you're sitting on and how to look on this. So if you're Callaway, if you get served a notice to preserve, you're going to theoretically do so in compliance with what is requested of you from TaylorMade. Now, TaylorMade, and I would probably say not one stitch more if I was Callaway. And certainly they would claim no requirements to preserve influencers or other people that they may have contracts with who are not Callaway employees, who are not their devices, their phones, their social media pages are not owned or managed or operated by Callaway. They would likely claim no ownership and no ability to preserve. If you're TaylorMade, I think you very quickly have to figure out if this is the tail wagging the dog or the dog wagging the tail. And what I mean by that is it the influencers that are causing the market and the external people purchasing the balls like us sitting on this call to watch those social media posts, watch those reels, and their retail sales are diminishing? Or is it the internal folks at Callaway who are pushing as they said, the reps who are doing these live demonstrations to pro shops, to professionals, to golf courses, to things where they're doing big commercial buys, to the PGA Tour superstores of the world or the Dick's Sporting Goods, where before it gets to us, that is causing lower wholesale purchasing. And depending on where they believe that impact has been felt is going to change their strategy on how they then have to request that preservation and what specific items they're going to need to look for. Because they may be able to circumvent the influencer data and the non-party data if they believe that their argument lies purely in Callaway employees who are doing demonstrations to wholesale accounts or to let's say golf courses. And that will then shape how damages will ultimately have to be calculated, and it may create a lower number, it may create a bigger number, but it likely creates a more concrete analysis for TaylorMade than trying to anticipate the full ripple effect outreach of something like influencer data and how many people that impacted, and then trying to aggregate third-party data from all of those individual retailers of how many they've sold, not how many Callaway has sold itself to those third-party retailers.
That makes sense. I've got a similar question for both of you, kind of on the same line of thought, going from preservation to how that particularly impacts damages. Thinking about the hypotheticals of a case like this, one thing that comes to mind as well is structured data and the actual testing of the golf balls, right? If it were deemed relevant, how Callaway tested their golf balls, and if they had knowledge based on their testing as to how the cover and the amount of UV chemicals in that actually impacts performance. Mark, where would you find that? Where would you find that, and where would you need to preserve that data? And then Teddy, how much does that implication impact damages?
Yeah, I mean, I don't know specifically exactly what systems they use, but you would expect, as you said, some type of structured database tracking the results of their testing, as well as internal memos, reports, etc., that will be relevant to this. So it'll be a combination of structured and unstructured data.
Well, I can actually speak on a little bit of experience to that. I took a tour of a manufacturing facility as well as an R&D facility for another golf manufacturer out in that Southern California area, out in Oceanside. We won't name the names, but they're not a party to this, but one of the, if not the largest golf ball producer and seller in the country, if not the world, and saw firsthand not only the testing they do on the golf balls and what tests they go through and how they test them, but the amount of rigor that goes into it, the amount of rigor that goes into testing all of their equipment and all of their technology years in advance, and how they look at it. So just quickly from a golf ball perspective, there's an entire area within this company's facility that all they do is take golf balls that are produced from their golf ball production factories and pulls out random sampling from it, and they pretend to hit it with a wedge hundreds of times. They simulate hitting it with the driver hundreds of times. They test all the different elements. They cut them in half to look for consistency. They do all of these tests and verifications to make sure that the golf balls that they are receiving meets the standards and the specs that they've set. But even before they get there, in their top secret area, they call it Area 52, the place that I went to, they are using 3D printing, CAD machines. They are using effectively homemade supercomputers in which they've got 5 towers with a circulating 360 camera that images every dimple, every groove, everything of every club face and golf ball, so that they can then create actual 3D modeling within computers. And before they even make the first 3D printing of a model, which they don't make physical metal clubs or golf balls anymore to test, they make 3D models first to test them via the computer before they actually print something. So there are lots of systems in which these sources rely, and they certainly would know if something that they have done, a brand as big as TaylorMade, certainly knows if they've made the changes that will cause this performance issues, because they have golf balls that have pixels on them, that are yellow, that are multi-branded colors, all the special logos, And I am certain that they are not putting those out and putting those in the hands of professionals if they have not been thoroughly tested.
So many data sources. All I could hear was just an embarrassment of riches of data sources to potentially
100%.
collect. Oh my God.
Well, Teddy, then how does that impact damages if they're able to prove, or either side is able to prove the ultimate question here, which is, does golf ball coating, affect performance?
So the almost sad thing is it has a de minimis effect on the actual damages, because the actual damages are a result of ultimate customer perception and performance. So what did the consumer, what did the wholesaler, what did they do? Now, from a legal standing, the forensic data is extremely important to be able to craft the legal arguments to help establish those claims of libel, those claims of false advertising, and say that they have tested these, and I'm certain Callaway has tested those, and they are aware internally, and if there likely is a document that would exist, that they have seen the performance differences between paint colorings or UV additives in covers of golf balls, that someone within both organizations are aware on what they do and do not affect. And so it certainly is a large point of issue for the establishing the liability for the various claims, but sadly, money is what it's all in the perception of what we believe or don't believe and how we as consumers act upon it, truthful or not.
So
That makes sense.
Sounds like, so Mark, in a situation like this, in most situations, it's like, this is, the data sources may change, right? Because of the type of case it is, or the type of company it is. But in essence, this is really similar. Mark is collecting and analyzing data to understand the universe of what we're dealing with, right? The universe under which liability is going to be established. And then once that universe gets created, Teddy, you come in to help understand what harm occurred within that universe, so that we could equate, like a quantifiable dollar amount to it. But the universe has to be defined first through collection of data and assessment, analysis, and stuff like that, if I'm understanding you correct.
Absolutely. And I'll also let Mark talk about how he does it. But each claim could carry a different amount, could carry a different dollar figure, could carry a different way in which you have to go about quantifying it. Because certain IP damages have theories under case law or versus lost profits versus disgorgement. There are multiple theories. And so it really depends on where the data points it to.
Yeah, I like to think that, the digital forensics preservation phase is kind of the foundations of the case. We're in very, very early and we're preserving. It's very important to do it correctly at that point, because there's no going back, especially in data sources that are so volatile as social media. And then I look at what, when we collaborate with Teddy, he's building the structure on top based on the foundations that we've collected. And, building that timeline of who knew what when is kind of very key in terms of helping Teddy do his analysis.
Yeah. I hate that I have to ask this, because I feel like everyone asks it. But how does moving a bit from the collection to the authenticity, how does the world of social media and the fact that so much data is AI generated today impact the collection, the authenticity of what you've collected, impact your research and investigation into finding what to collect with these social media sources? And Mark, can you just shed some light on the current landscape of the world that we're in today and how that changes things from maybe a few years ago?
Sure. Certainly the explosion of AI and the ability of manipulating pictures or videos or creating has obviously made it more challenging to authenticate. Obviously, when you're preserving these data, you need to be using tools You know, a screenshot is not going to do it. And so you need specific tools that will collect it and collect the metadata around it. You know, the metadata of the platform it's on, the metadata of, you know, the internally of the files. And so, you know, a lot of these AI tools, when they do manipulate videos, they leave encoding traces that we can look for, and other just inconsistencies in date, etc., in the EXIF information and metadata within the files itself. So we take a look at that. But really, you know, chain of custody, the person doing it being capable and experienced. You know, one of the challenges that we do see is it's very, very quick from when you get a reasonable expectation to preserve, or a reasonable expectation of litigation to preserve, then 3 years later you're in court talking about it. And if a guy from IT does it and he does it well, but he's no longer there or didn't take good notes, it can always open challenges, especially with this new world where it's so easy to manipulate these. So really having an expert doing it, being able to attest to what they did, obviously securing it once they've collected it, making sure there's no manipulation, hash files, and other chain of custody type stuff that will really protect your case when it can be open to challenges from the other.
Awesome.
Actually, I have a question for Mark? I'm gonna jump in and steal the job, Drew. I apologize. As you were talking, I was thinking about this. I could envision a world in where you have influencer marketing and you have the social media influencers in the golf world that have sort of taken over a lot of the YouTube and Instagram space. But have you seen, or would you anticipate looking for potential AI generated content, non-real, or so artificial intelligence influencers that may or may not be agents of the company itself, where it appears that is a third party or someone presenting as an outside source, but in reality is inside source? And how would you go about investigating that?
You know, I'd think about trying to find the source of the document, source of the media file, sorry. It's kind of an outside in investigation. So you're looking at the publicly available stuff and then you kind of track it back. So you would want to get, if you suspect it was an employee, for example, you would want to try and get the business assets or the assets where it's created and try and follow it back to the creation of that file, to try and find some ownership. There might be some indications that it was a fake video. You know, certain AI tools leave codecs in there and different encodings and stuff like that that might give us indications that it wasn't a legit. Because obviously, if it's a legit video, you know, often it will have the make and model, it'll have maybe geolocation if that's present. A lot of stuff that we'd expect to see that won't be there or will be there but doesn't seem right. So, you know, we'd look for little clues to try and investigate that.
That I think that is becoming more and more of a relevant topic. Yeah, so it's good that iDS, that we're already on the forefront of thinking about that. As we start to wrap up here, you know, if Mark, Teddy, if you guys could advise your clients, you know, in one way, what's one takeaway, one thing that they should be remembering from this conversation?
Mark, you want to go first?
Sure.
To forensics.
Sure. I guess I would say, you know, in this digital age, we're living in distributed, volatile data sources that it spreads across all these platforms that you don't control, which we used to be in control of, and through people who may not be employees. So it's also key to always understand that you're going to need collaboration to get non-public stuff. So when you're planning out a case like this, a false advertising case, for example, is to identify them and also get out to them quickly, because a lot of these influencers, they don't understand the implications of litigation and they might get spooked and delete. So getting in front of them early, and, you know, trying to preserve that is key. You know, the forensics challenge is to capture the data before it disappears. authenticate what we've collected, and then trace it back to its source?
I would say from my perspective, again, it's a different answer for which side you may end up on litigation, but it's sort of salient to every company to prevent this from happening. So in this case, if you're on Callaway's side, the sort of the salient advice would be that, as Mark said, those influencers who may not be under your domain, who may not use company devices, who may just be someone that you've signed a contract with to promote your product, don't necessarily have your company's sole interest and best interest in everything that they do. And so what they do and put out in the market sometimes has greater effect on market activity than the company itself, which is why influencers have, I think I've heard somewhere, have taken over as the number one sort of job that the next generation wants to take over. It's no longer movie star and it's no longer athlete, it's influencer. And from the flip side, so if you're TaylorMade, neither of these companies are going out of business. Neither are no longer going to be selling golf balls. They are not permanently harmed by this, and I don't think there's any claims of permanent harm. As you said, Drew, the product cycle for these companies are 12 months, and so they've already got their next ball in sort of in the queue and in testing, and it will come out. And if they have to put that up faster, maybe they move production up to get ahead of this. But in the interim, it is really important as you are pursuing this litigation that you are not penny wise and pound foolish in trying to say, I want to capture every possible avenue in which that they have harmed me under the sun, and I'm going to take this on an initiative that is going to create lots of work for us, but at the end of the day may not be the avenue or the path that is truly where the harm is. And so I think understanding your own company and where you really think you've been harmed, not you kind of guess, but you can't really quantify it, but you've got company purchasing history, you've got books and records that actually account for what you're seeing in your profit and loss statements, then I think those are the areas to really kind of sharpen those blades, and clean out the grooves on those elements of your claim, because that's where you can get the most impact.
Really, really comprehensive episode. What were you gonna say, Drew?
I was just gonna say I've got a couple of takeaways. First thing, I am always astonished, and I think the golf industry is just representative of global industry in general. I'm always surprised by how much data resides in places that I wouldn't think about, right? Like 3D modeling of golf clubs and golf balls before the testing ever even takes place. The supercomputer stacks that Teddy was talking about. I mean, there's just data everywhere. And the other takeaway I've got is I mean, there's a Costco versus Titleist lawsuit, Costco versus TaylorMade. There's the PIF and Live downfall. I think we need just like an iDS golf podcast. There's enough content here we could talk for weeks.
Look, I don't know if I have any specific takeaways because you all have been so comprehensive. In a podcast where we're talking about golf, we've gotten good words to live by from Teddy. We've gotten a discussion about AI, which I don't think you could talk about data without talking about AI at this point in our digital lives. And great idea, Drew. Let's explore what else we can do with golf. I think this episode was a hole in one. Sorry, guys. So look, thank you, everybody. Mark, I really appreciate you. Teddy, really insightful content. Appreciate you both joining us today. Drew, thank you for continuing to take this ride with me. And I'll see you on the next episode. And hopefully you all found this insightful. If you want to learn more, just visit ids.com or connect with us on LinkedIn. And if you found today's episode helpful, if you found the information enriching, talk to a friend, talk to a colleague, tell them to give it a listen. At iDS, we don't just manage data. Of course we do that, but we also seek to understand truth through data. We're trying to get insights and help our clients understand what the story the data is telling us a little bit better. Thank you all for joining us. We'll see you all on the next episode. And if you want to read the article written by Mark and Teddy, I am sure the link is included